Hi, my name is Amanda Rocha. I'm an estate planning and probate attorney in California, and today I want to talk to you about naming a guardian for your minor children. Now, before I get into the importance of this and considerations you should take, I want to give you my contact information in case you need to reach me. You can find me on my website, www.amandarocalaw.com. On my website, you can either fill out a form to contact me with a specific question, or you can schedule a consultation with me directly through my calendar. You can comment down below if this platform allows you to do that, or you can reach me through my social media at Amanda Rocha Law. There you can send me a direct message. Now, naming a guardian for your minor children. If you're here and watching this, that means that you are already ahead of the curve. You are thinking about what could happen to you, whether that means incapacitation or, unfortunately, death. And the important thing to know right away is that any guardian that you would name will likely be better than someone that an impartial judge would name. So you're making the right decision by doing it yourself. There are multiple ways you can do this. The first thing I want to talk to you about is how to name a guardian. Then we'll get into the importance of it and considerations. First, there are two ways to name a guardian. One, you can name a guardian in your will, and that's great. You can say who you would want to take care of your children when you pass away. However, if you become incapacitated for any reason, whether for short-term, long-term, or otherwise, the will is not effective unless you pass away. So there would still need to be a hearing or multiple hearings and people fighting over who would be named your children's guardian in that case. And for that reason, I recommend that you fill out a declaration of a guardian in advance. This is in addition to a will, because I also think that everyone should have a will. But this declaration will give your wishes in a legal form, both for incapacitation and death. So if your will were to fail, this document would still be okay as long as it was filled out correctly. Now, choosing a guardian is the most difficult part. Nobody will ever be as good of a parent for your child as you are, and you're going to have to accept that right away and make decisions in spite of that. There are very important considerations you need to take under. First, how well does your guardian actually know your child? It could be your best friend, someone that you grew up with, you know very well and you trust, but have your children met them? Do your children know them? Do they feel comfortable together? That's something that you have to take into consideration. Also, what is this person or person's parenting style? Do they share similar morals to you? Is their religious and spiritual belief something that you are okay with? Where do they live? Will your children have to completely leave their locale, all of their friends, their school? Again, this is something that is just one consideration to make, but an important one. You also need to take into consideration the age and health of the person or persons that you're naming as a guardian. If this person is significantly older than you, they could pass away before you are able to change the guardian declaration. Or they could decline in health and maybe you forget to change it, or you don't have a chance yourself to change it before it needs to be used. Another thing to consider is the emotional preparedness of the person or persons that you're naming as guardian for your children. Are they single? Do they have children themselves? Would they know what to do? Of course, you can leave letters, you can record a video if you like, as much information as you need, but the fact is, and you know this as a parent, that until you're a parent, you don't understand what it's like to be a parent. So these are some of the many considerations you should make. However, don't let the considerations stop you from actually making the decision. You can always change it. If you change your mind in a week, a month, a year, you can change this document. The important part is that your children will have something in place in case something were to happen to you tomorrow. Now, another thing that you should think of is letting these people know that you're naming them as a guardian. Because your sister might assume that she would take your children if something were to happen to you, but let's say you chose your brother or your best friend. It's going to prevent a fight if everyone knows what you have planned, and it's also going to prepare people who may not know that they are the person that you would choose. It's an important decision, but one that you should make. If you have any questions about this, you can again contact me on my website, www.amandarocalaw.com, on social media at Amanda Rocha Law, or comment down below if this platform allows you to do that. Thank you.